Good evening, listeners. Welcome to the 2nd August 2022 episode of Property Focus program, a program from Horizon Properties, the real property merchants. Greetings from the Horizon Properties team. We're here to continue to disseminate information, very important information to the public regarding the relationship between the landlord and the tenant of the dwelling house. This is a relationship which is governed by law. This relationship between the landlord and the tenant of a dwelling house is governed by a Cap 206 of the laws of Zambia. On the other hand, in a coming episodes, programs, we'll also be looking at the relationship between the landlord and the tenant of the Business Premises Act, this is Cap 193. So for the time being, we'll be now looking at this very interesting and challenging relationship between the landlord and the tenant of the dwelling house. Last time, I explained the importance of having a lease agreement, which is a civil agreement between parties stipulating the obligations of the parties concerned, that is the landlord and the tenant. I remind you that this is an agreement of obligations that becomes enforceable in course of law. This is very, very important that tenants and landlords should have a lease agreement which stipulates the names of the parties involved, the tenant and the landlord, description of the premises, because the premises must be known in terms of location and its allocated number. The period of the lease must be known when it's starting and when it's ending. This allows you to also to be able to know when to give notice for vacation, give a vacant possession, or when the landlord would like to terminate their use agreement. The rental charge must be known so as to avoid future conflicts in terms of payments and also in the manner how you should be paying the rentals. Also need to agree on the additional fees, charges regarding electricity, water, and garbage. Very important clause which you should not miss is the clause of termination. How do you agree to terminate this agreement? Today I'd like to talk about, to educate you on two aspects of a lease agreement, which needs to be very clear when you are drafting or when you are contracting or assigning obligations. There's this issue which has been contentious to do with the repairs. Repairs must be also to avoid conflict between the two parties. It's very important also to clearly stipulate who does what. However, the tenants, the Rent Act, which is the act governing the relation between the tenant and the landlord of a dwelling house, presumes that the tenant, the landlord, should keep the house in good order, and also the tenant must leave the house as it was found. Listeners, Section 24 of Cap 206, it is deemed that the obligation of the landlord of any premises to maintain and keep the premises in a state of good order, good repair, and in a condition suitable for human habitation. And it shall be deemed to be the obligation of the tenant to maintain the premises in the same status that which the premises were found at the commencement of the tenancy. There have been conflicts, a lot of conflicts and misunderstanding between landlords and tenants regarding this aspect. As the law prescribes, the landlord must keep the house, must present the house to the tenant in good order, in the order of good human habitation, and also the tenant, when leaving the house, must leave the house in the same way the house was found. There have been a lot of fights on this issue, but I think the Act guides clearly that the house must be left as it was found. Many landlords would like the tenant to paint the house which they found unpainted. It's not law, it's not regulation for the tenant to start now uplifting the condition of the house they found as it was found. So this is very, very important. Tenants leave their house in good order as it was delivered to you, and the landlords should maintain the house in good order at the point of commencement of the tenancy. The other pertinent issue which are in the lease, which needs very good understanding, is termination. Termination. Many instances find that people contract without written leases, and there comes time of giving vacant possession. There comes serious misunderstandings. Section 13 of Cap 206 provides instances where a tenant can evict, a landlord can evict a tenant. Ideally, there are about only 3 situations where a landlord can have the right to evict you. On the other hand, a landlord may not evict you without a reasonable cause among the 4 I'm going to mention, and it's contentious in course of law. You can get your tenancy can be extended or renewed through court if the landlord does not have justifiable reason not for him or her to terminate. Section 13, Cap 204, 1A, the one instance where the landlord can evict you is where you are failed to pay rent as agreed, or to perform your obligation in the tenancy as agreed. As I mentioned, the lease agreement is a lease of obligations. If you cannot abide by the obligations within the tenancy, your tenancy may be terminated. If the landlord requires to use the house as a residence, notice is not less than 12 months. But I think in most cases, because of the scarcity of housing, landlords do not abide by the law. They can terminate. In most cases, they terminate anyhow if they want to occupy the house. But if the landlord wants to occupy the house that they had put on rent, they need a notice of 12 months as a tenant, to be given a notice of 12 months. C, subsection 13, 1C, if the tenant or any other person has been guilty of conduct of nuisance or annoyance to the adjoining occupiers. If you have been, you're a nuisance to the neighbors, or you are to the neighboring adjoining house, your lease may be terminated. The landlord has got a right to terminate your tenants. The fourth reason where a landlord may terminate your lease, you may be evicted, is when the premises is used for criminal or illegal activities. For example, if you're using the house as a storage to distribute illegal drugs, or you are using the house for selling illegal drinks, then the landlord has a right to terminate the lease. So these are the 4 instances where the landlord has got a right to terminate the lease. On the other hand, the landlord must have a justifiable reason for them to terminate your lease. You have a right to contest termination if your termination is not based on those 4 items I've just mentioned. 1, you are not paying as agreed. 2, the landlord wants to use the house as the residence. 3, you have become a nuisance. You come in the night and shout. People don't sleep. You become a nuisance. We are annoying the adjoining the neighbors. And number 4, if you are using the premises for illegal activities or you are harboring criminals, then those reasons, if not among those reasons, you can contest termination in the course of law. As I mentioned, this Rent Act was mainly meant to protect the tenants. So listeners, this is information. We'll be giving you some more information arising from the lease. We'll be talking about notices. How much notice do you need to be evicted or to be given notice to leave? So we'll be going through all these contentious issues in the relation between the tenant and the landlord. If you have any questions regarding the relation between the landlord and tenant, you can send your questions or questions or comment on info@thehorizonproperties.com. Send your questions to the info@thehorizonproperties.com. Then we'll be able to respond and give explanation, any clarification, or only you have a situation where you feel your rights have been violated or infringed upon, and you need guidance with regard to the tenancy. Send your questions at info@thehorizonproperties.com.